Good afternoon, everyone, and welcome to today's session of our Wednesday coffee break, where we're going to be discussing the recent non-competition ban with one of the firm's up-and-coming associates, Tony Dalimonte, who is, I will say, a go-to person for me, and I think almost everyone at the firm nowadays. Tony, pleasure to have you here, and thank you for coming in to talk about the recent FTC rule on non-competition bans.
Yeah, thanks, Rob. Thanks for having me.
Awesome, awesome. So, why don't we jump right on into this? Why don't you tell us a little bit about what's going on with this new FTC rule that we've all been hearing about and its effect on non-competition agreements?
Yeah, absolutely. So the FTC voted on April 23rd, 2024, voted along party lines to publish its final rule banning all non-compete agreements. And the rule states that non-compete agreements violate Section 5 of the Federal Trade Commission Act, and it essentially bans all non-compete agreements signed after the effective date, as well as all previously signed non-compete agreements, except for senior executives. And I'll talk about that in a second, but the effective date on this rule is September 4th, 2024. So we got a couple months now, a little less than 3 months before it's set to become effective. Um, and I just want to touch on that senior executive sort of portion of it. So if you got a business and you signed a non-compete agreement, those are unenforceable except for senior executives. And a senior executive, according to the FTC, is someone who makes over $151,164 and is in a policy making position. Now, what that means, we're not exactly sure right now. But the FTC has commented and said that they believe less than 1% of employees fall into this sort of senior executive bucket. Um, and the idea behind this carve out for senior executives is that the FTC believes that, if you have a higher wage employee, they're more likely to negotiate these agreements and they're, less likely to be, according to the FTC, harmful. But an employee's job title is not considered. The only thing that would be considered are their responsibilities and job duties. And this rule is going to cover nearly all industries and nearly all types of businesses. So it's a pretty big deal.
Yeah. And so you talked about a lot of things in that answer, right? Let's back up first. So this is an FTC rule. This isn't a law, right? Can you kind of explain a little bit about the difference between that?
Yeah, so it's what we have here is a federal agency in the Federal Trade Commission essentially making federal law through this rule. And so if it goes into effect in September, it will preempt all conflicting state laws. So under Michigan law, as we know, non-compete agreements fall under this reasonableness standard and are permitted. However, if this rule goes into effect, um, you know, the Michigan law will be changed and the federal FTC rule will govern.
Okay, so this isn't something that went through Congress. This is something that went through committee, it sounds like.
It went through committee, and we have, I believe, five commissioners on the FTC board, and they voted along party lines three
Yeah.
two to pass the rule, as most everyone expected that they would.
Yeah, and we've seen a lot of this lately. I know I found a few of the rulemaking lawsuits. You see it a lot in environmental law. You see it a lot, obviously in the HR law and firearm regulations, things like that, where you get these agencies that are essentially, as people argue, making law. And what is the effect of that? And is that allowable? Isn't that allowable? So it's a really interesting and very academic area. But I think it's important to note, that this was something that was done via, an administrative policy, not via Congress and the regular lawmaking process. So, with that in mind, the term non-compete can mean a lot of different things, right? And there's some things that are similar, right? You have non-competes, you have non-solicitations, you have, non-disparagements, right? There's a lot of nons in many employment agreements that we see that we write on a fairly regular basis. So can you get into a little bit more about what a non-competition or a non-compete is under the rule? Is that defined? What are your thoughts?
Yes, so the FTC says that a non-compete clause is a term or condition that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work, at another employer or starting a business that does the same thing that, the current employer does. So essentially anything that prohibits a worker from going down the street and working would function or is a non-compete clause. And I just want to back up 1 second, Rob. One thing I didn't mention that I want to emphasize to everyone is that not only are the non-competes banned under this rule, but also employers have an obligation to send out notice to workers that previously signed a non-compete agreement, basically telling them that, hey, this isn't enforceable anymore. We're not going to enforce it against you. Just letting you know. And so it's a big deal. And this notice requirement is going to be something that is going to be important as we get closer to this impending September deadline.
Yeah, and I definitely want to talk about the notice requirement, in a second, because that's something that you don't see that often, right? Look, we've seen rulemaking, we've seen changes in the law and all of those things. A lot of the agreements are grandfathered. A lot of the provisions say, you can't enforce it moving forward, but to have to proactively notify people and have that be a separate requirement and a separate hoop you have to jump through is, I think, a little unique. I haven't seen that often, in other similar laws. So I'd like to circle back on that. But again, before we move into that, it sounds like a non-competition or a non-compete under this rule is a little expansive, right? Look, we've seen cases beforehand. There was the Jimmy John's case, right? Where went to the Supreme Court that Jimmy John's in their employment agreement tried to prohibit, competition by saying, if you worked on our line, spreading mayonnaise on a sandwich, you couldn't work with other fast food industries, right? And I might be paraphrasing the factual scenario, but court said no, that's not enforceable, right? So it sounds like we're getting away from that reasonableness standard and just going to a complete 100%. Doesn't matter on whether it's reasonable. If this restricts you in any way, shape, or form, unless you fall under that exemption, right? The provision is illegal. Is that
Yeah,
a
I
fair and
mean,
accurate?
it's essentially a blanket ban. There are three small exceptions to this rule. The first is for a bona fide sale of a business. So if you sell your interest in a business entity, if you sell your business or you sell substantially all of a business's assets, the FTC says, if you enter into a non-compete that says that, hey, Jimmy can't go set up a shop down the street of the business that he just sold, that's okay. The second exception is for existing causes of action, which is kind of interesting. So it essentially says that if you previously had a non-compete and the worker breached that non-compete before the effective date of this rule, you still have a cause of action to sue them for that breach. After that rule, it's a little dicier, and I think there's questions on damages. But
Yeah.
this is kind of an interesting exception where, if you were thinking about potentially going after an employee for a breach of these agreements, there's a pretty limited window here. And then the
Yeah.
third exception is the sort of good faith exception, which means that we've talked about the senior executives. If you had an employee who signed a non-compete before, and you think they fall under this senior executive bucket, they're over the income threshold, and you think they're in a policy making position, and they breach that non-compete, and you sue them, it's not a violation of the rule if you have a good faith basis to believe that they, were a senior executive and you could enforce those rules. But other than that, it's a blanket rule against all non-compete bans.
Got it. Now, does this just fall under, non-compete clauses? What about some of those other broad restrictions, or narrow restrictions, I guess, depending on how you draft it in the actual agreement. But what about some of those other restrictions that we see typically in, certain employment agreements, engagement agreements, things like that?
So in general, yes, the FTC was careful in their wording. They said, yes, it only applies to non-compete clauses, but they left sort of the door open a little bit to say that these other agreements, non-disclosure agreements, non-solicits, confidentiality agreements, if they function as a non-compete, then they could be treated as a non-compete and, would be banned under this rule. And the FTC says that this is a case by case basis thing. And so, for example, if you had a worker who's left his employment, let's say at a mechanic shop, and the employer had him sign a non-solicitation agreement before he walked out the door, and the non-solicit said, "Hey, you can't advertise in Michigan, in this area for an entire year." The FTC may treat that as a functional non-compete because essentially you're prohibiting him from going and opening up a shop across the street. Um, the other sort of functional non-compete the FTC identifies are trap agreements or training repayment agreements, where if an employee leaves before a specified date and you have an agreement that says that they have to pay you X amount of money, the FTC didn't come out and say those would be banned, but that was one that they identified could fall into this sort of functional category.
Yeah. So I'm putting my employer hat on for this for a moment here. I could hire someone. I could train them on how to do, XYZ job. I can give them access to my systems. I can give them access to my book of business, all the things that are necessary for them to do their job, right? Not saying that I'm granting them broad access because I felt like it, but again, they're going to have customer contact. They're going to have access to the customer list. They're going to have access to all of those. And if I put in a provision in my agreement that says, hey, you can't take my customer list and you can't go open up your shop and solicit the customers in the field that I taught you, in the systems that I gave you, in the customer list that you had access to, I might not be able to enforce that under this rule.
Taking the FTC at what they
Yeah.
say that non-solicits are enforceable, but that, like I said, that door's open a little bit where there's a little wiggle room to make the argument that no, this functions as a non-compete.
Yeah.
So, it's a little, it's clear as mud, Rob. And these other agreements are enforceable. You just got to be a little careful that you're not crossing the line into prohibiting someone from working for another employer or opening up their own business. The FTC says that, yes, they want employers to protect their proprietary information and protect their customer list. And there's other ways to do that other than non-compete agreements. But knowing that, you still got that door's open a little
Yeah.
bit, and it makes us a little worried.
But if you use those other, provisions, those other ways, then we may still come after you. So,
Exactly.
all right. Well, that's again, as you say, clear as mud
Yeah.
is probably a good way. And unfortunately, I think this is what sometimes comes out of the rulemaking process, right? It's a very limited process. You don't have the broad input that you sometimes get with congressional approval, right? So again, it I think this is also unfortunately a byproduct of the process as much as it is a byproduct or an actual intended product of the rule itself.
Yeah.
Um, so what can businesses do? First of all, what can businesses do to prepare for this? It sounds like we have to talk about what's in their current agreements, what they're going to be having to deal with in the future vis-a-vis agreements. And then I'd also like you to talk about that notice provision, because I think now's a good time to circle back on it.
Absolutely. So there's a few things that businesses can do. We recommend that you take stock of who you've had sign a non-compete and whether, new employees are required to sign non-competes. What's their job title? What's their job function? And at its core, what are you trying to protect? Are you worried about the customer lists? Are there other tools in the toolbox that can protect, the things that you want to protect that may not necessarily, be in the form of a non-compete agreement?
Mhm.
And, circling back to this notice, if this rule goes into effect in September, like I mentioned, employers are going to be required to send out that notice that says that, hey, if you had a non-compete, we're not going to enforce it against you. And it's interesting because the FTC gives you a model notice to follow, and it's kind of a crazy notice. They recommend that you send it out to all employees. They tell you to hit email all, and it basically says that, if you've got a non-compete, we won't enforce it. It actually says you may go run your own business that competes with us. You may go work at an employer that competes with us. And so, we're not recommending that you go out and you send these notices now. We have a little less than 3 months before the rule would go into effect. If we get a little bit closer, we can start talking about that. But I think really just taking stock of, what you're trying to protect, how you're doing it, who you're having sign non-competes, and do sort of an internal audit there.
Yeah. And with that audit, it sounds like, and you may have to put it into two separate tranches, but number one, those that are on a non-compete, and then two, those that aren't on a non-compete, but maybe under some other restrictive covenant that may function as a non-competition, right? So
Exactly.
if let's just say your salespeople aren't on non-competes because it's the nature of the business, but you do have non-solicitation and perhaps non-disparagement provisions. I think that companies should seriously look at doing the accounting on that, right? Taking stock of those potential people, and then evaluating whether or not those other types of restrictive covenants pass muster under this new, arguably vague rule.
Yep. Yeah,
Okay.
I agree. And, the FTC gives you, three things that businesses can do to prepare. They tell you don't sign non-competes in the future. If you have active non-competes, send out the notice and don't enforce your existing non-competes except against senior executives. Again, we're not recommending that you go that far at this
Yeah.
point in time, but if we're getting close to September 4th and this rule hasn't been struck down, then we're going to have to start talking about that.
Yeah, and I want to talk about the challenges that are coming up here because it's inevitable that this is going to be challenged, right? It's going to be challenged under the process. It's going to be challenged on the content, right? So we know that that's coming down the pipe, and I'd like to talk about that here in a second. But before we do, I do also want to talk a little bit more about that notice provision that you were saying. It sounds like it's you know. I guess on a pendulum, it may have the notice may have swung a little, too far, right? It's not just saying, hey, we're not going to enforce your non-competition. It's saying, hey, you can also leave us. You can start your business. You can do X, Y, Z. Is that model notice required under the rule, or is it just kind of a suggestion? What's the threshold?
So it's not required. But if you use that model and you got audited by the FTC, for example, and you could show, hey, I'm using your notice, that would probably help you in whatever audit came down. That being said, all that you're required to do is send out notices to employees or workers who previously signed non-competes. You don't need to follow their model, but there are benefits to following the model.
It's
But
kind of a
again,
safe harbor. It's a
exactly, it's a
Yeah.
safe harbor.
Okay.
But the safe harbor goes a little bit too far in our opinion. Like I said, it says that you can go down the street and work for the competitor, and it says that you can go open up your own shop.
Yeah.
I think that's it might be better accomplished by sending out individual notices, but it would have to be a case by case basis.
Yeah. So it sounds also like employers that, may have a little bit more lead time in, trying to comply with this rule, again, assuming that it moves forward. Another thing that they can do is look at that model notice, right? Start having the internal discussion whether or not they want to use the model and avail themselves of the safe harbor, or if for some reason they don't want to use the model, start drafting and start considering what they're going to put in that notice to make sure that if they're required to, they can get that out timely. Does that also sound like something that can be done pretty
Yeah,
early?
absolutely. Yeah, we've got some time now. If anyone wants to look at that model notice, shoot Robert or I an email. We can send that over to you. Take a look. It's not impending yet, but that would be a decision that each employer would have to make on how they want to handle that.
All right. And then let's circle back to the elephant in the room, right? Is this going forward? Is this going to be challenged? What's likelihood? And I know you're eager to talk about that.
Yeah, so it was challenged almost immediately in the Northern District of Texas by a tax firm. And we're watching this case closely. This was the case that was first to file and is sort of, leading the pack here. And uh, the tax firm in that case asked the court to issue a nationwide block on the rule. And we're actually supposed to get a ruling on that motion, I believe, July 3rd. There's supposed to be hearings happening soon. So we're probably going to know whether or not the rule is paused or overturned within a month, which is why we're not recommending at this point that you go out and you send out all these notices. But in general, legal commentators on this issue believe that the rule will be overturned. And the reason is what you touched on before, Rob. We have a federal agency here who wasn't elected by the people, who can't be voted out when they get things wrong. And they've essentially made sweeping countrywide changes in the law, abrogating over 45 states, non-compete laws. So that's a big deal. And, the idea is that, the FTC doesn't have the authority to do this. But until there's a court that says that the rule is overturned or unconstitutional or paused, we have to assume that it may go into effect in September, until we're told otherwise.
Yeah, it's a very similar argument to the West Virginia versus the EPA case from a few years ago, where the EPA issued these sweeping rulemaking changes. It was challenged, saying this is effectively making law, not carrying out rules and administrative. And the Supreme Court shut it down. So
Yep.
it sounds like it's a very similar issue. Now, the other interesting part about this, and we're seeing this with one of my favorite topics, the Corporate Transparency Act, where that was actually a piece of legislation, right? It wasn't rulemaking, but it was done through Congress, where it's being challenged, and the places that are challenging it aren't getting broad sweeping injunctions. They're getting very narrowly tailored injunctions, right? In one of the cases, it was only members of the plaintiff, and it was some sort of chamber of commerce. I can't remember which one. So obviously, everyone rushed to join that chamber of commerce when that ruling came out. So even if there is an injunction, the question is it going to be a nationwide injunction? Or if it's not a nationwide injunction, does it extend to your particular jurisdiction, right? So it sounds like that case is in Texas, if I remember you correctly. Whether that results in a large nationwide injunction or not still remains to be seen. So we may get patchwork where it's enjoined in Texas, but Michigan hasn't ruled, and you still have to comply with it. So it's a really interesting and somewhat academic, power, and unfortunately it has real world impact on businesses, right? They don't know what to do. We're 2-3 months away from the enforcement of this. There's certainly lead time to getting this project underway. So unfortunately, I think that everyone has to, while they hope for, the best, I guess, depending on your view on this, right? But if you hope that this rule is going to get overturned, I don't think that most businesses can, just kind of rest on the issue. They've got to start preparing for it, and at least doing that initial analysis, right?
Yeah, exactly. And you hit the nail on the head. We don't know for sure what this Northern District of Texas case is going to do. They could issue an injunction just to the plaintiff. They could issue a nationwide injunction. We just don't know right now. And so, it is really important for businesses at minimum to just take stock of what they're doing right now. Look at your agreements, figure out who signed these agreements, and if you need any help, or if you want to speak to someone about the tools in the toolbox on how to protect your proprietary information, there's lots of tools out there that we can assist with. But we're watching this case. I'm sure it will be all over the news once something happens in July. But I think we'll have a pretty good idea after early July about what's going to happen and whether or not employers need to start ramping up and start drafting these notices to send out.
Got it. And let's just level set where we're at. If this FTC rule, doesn't go in effect, doesn't supersede Michigan law, right? And understand that, every year people in Congress propose changes to Michigan's law regarding non-competes. It's been that way for the last at least 20 years, probably longer than that, right? But the current state of Michigan law uses basically a reasonableness standard, if I remember right, correct? It's not a, categorical absolute ban that the FTC rule is.
Exactly. And, I think there's been a pretty, nationwide trend, even at the state level, against non-compete agreements. This isn't just, coming from the federal level. Michigan's legislature proposes, a bill every couple of years on banning non-compete agreements. And we've even seen, in the course of litigation that, some courts and some judges don't like these things either.
Yeah.
They find that, there's other ways to protect your business other than arguably preventing someone from working somewhere else. And it's always a case by case basis, but you never know what's going to happen. They're technically enforceable in Michigan, but you never know what judge you're going to get. You never know what court you're going to get. So it depends. And like I said, there's other tools in the toolbox to protect your information and protect your business.
Got it. So, well, it's coming up on 12:30 here. We haven't seen any questions pop up in the chat, so I wanted to thank you for taking the time to talk about this. Unfortunately, it seems like we're still a little early in this process. We do need to wait and see what's going to happen with some of these challenges. I know that the Texas case isn't the only one that's out there, so. It's going to be interesting to see, how this progresses through the court system, and how everything plays out with respect to, what companies are doing to prepare for today. So either way, I did want to thank you for coming out and speaking with us regarding the ban on the non-competition agreements. I want to thank everyone for joining us today and learning a little bit more about the FTC rule, which bans non-competitions. And just let everyone know that we are going to be scheduling continued coffee break sessions, and we hope that you find these very valuable. And we look forward to seeing you at the next coffee break session. So thank you everyone for coming out. Tony, thank you for taking the time to speak with us today.
Thanks, Rob. You're the best.
All right, take care, everyone.